Morena, everybody. Thank you so much for joining us. My name's Yasmin and I'm from Belong Aotearoa. I'm here with our four fabulous speakers for today. We've got Deborah Manning, Margaret Robbins, Joy Kaur and Nicola Tiffin. Thank you so much. Good to see you all. Now, I know as usual, we're just waiting for a few more people to join, to get online and join us on the webinar. So before we get started, we're just going to share in the chat box. If you can share with us where you're joining us from today, that would be great. So if people via the chat box. Okay, so great. We've got some people. I can see some people sharing with us. And while people are sharing where they're joining us from in Aotearoa, I think I do know where our speakers are. I think we've got Deborah and Margaret. You'd be based here in Auckland, is that correct? Great. And Joy and Nicola, you'd be down in Christchurch, I think.
So I'm also in Auckland.
Oh, right. Oh, cool. Thanks, Joy. And Nicola, you're in Christchurch, yeah?
I'm the only mainlander here, yes.
Fantastic. No, it's good to have you. Good to have you all. Now, again, while we're just waiting for a few more people to join, we will pull up a couple of polls. So ask our audience just a couple of questions. That helps us understand a little bit more about your situations and things that may be concerning you. So I think behind the scenes, Malu, oh, here we go now. Thank you, Malu. So our first question is, how are you feeling about your current situation in New Zealand? And then our second one is, are you worried about losing your job? So if you could fill out that, answer those for us, that would be really great. Thank you. And we'll come back to that and see how people are responding. So thank you very much. Excellent. Okay, so I think we're doing pretty well with our numbers, and I can see, so we've got a number of people from Auckland, I come from Hong Kong. Yeah, so, oh, we've got Najira, who's one of our colleagues. Hi, Najira, hi to you. So that's really good. And lastly, this is the last webinar in our COVID-19 and employment webinar series. So we've been holding these over the last 5 or 6 weeks. If you've missed any of the webinars that we've held previously, you can catch up. So also through the chat box, we'll be sharing the link to where you can view those recordings, because we've had some great webinars over the weeks and some great speakers as well. So thanks very much. Okay, we've been given the go-ahead, so let's get properly started. So tēnā koutou katoa, and also talofa lava, as it is Samoan Language Week. Thanks for joining us. This is our final webinar in our series, and our topic today is getting the employment relationship back on track. So if we, Malu, if we can just bring up our slides now, that would be perfect. And if we move to the next slide, just to see a little bit about the format for today. So today, please, we're going to finish up with a Q&A session. So you can share your questions with us through the Q&A box. So please keep those questions coming, and we hope to get to as many of those questions as we can. And the other thing you can do is, if there's a question which someone else has asked that interests you, you can also upvote it. So you can click on the thumbs up icon to like that question. And the other thing we have is a chat box. If you have any other queries or technical issues going on, you can send us a message through the chat box, and one of the team will get back to you about that. That'd be great. So the format for today, firstly, we're going to hear from our employment law experts, Joy and Margaret, and they'll be talking about employment law during COVID, and particularly focusing in on some of the basic principles of employment law to help you understand your rights, and also what you can do if there are any problems or issues around in your employment. Then we'll move on to a brief immigration update from Nicola and Deborah. and I'll be introducing our speakers in more detail shortly. And then we'll have time for a longer Q&A session towards the end. So that's where we're really keen to hear your questions coming through. And we'll move to the next slide now. So behind the scenes, as usual, I have some wonderful colleagues working with me. So we've got Nadira, Sally and Malu, also from Belong Aotearoa. So thank you to those people for helping us out once again this week. And on to the next slide. So firstly, let's get into it. With our employment law focus, we're going to hear from Joy and Margaret. So a little bit about Joy. So Joy has extensive experience in employment law and workplace health and safety. She works at Anthony Harper Law Firm as a solicitor, and she advises on a wide range of employment matters. She works closely with clients to advise them on complex employment law issues and provides assistance with document drafting. And then following Joy, we'll hear from Margaret. So Margaret Robbins is a barrister and solicitor. She has practiced in employment law in Auckland for more than 30 years, and her specialist employment law practice is workplace law. And workplace law focuses on smart, straightforward solutions to employment problems for both employees and employers. A little bit more about Margaret, which it's a really impressive bio. So throughout her career, she has acted for hundreds of employees and has also provided services for a range of employers, including Greenpeace New Zealand, Auckland Rescue Helicopter Trust, BNZ and Sovereign Insurance. And lastly, on Margaret, she acted for refugees during the 1990s and was a member of the Refugee Appeals Tribunal for 10 years until 2009. Okay, so what we might do, Deborah and Nicola, if you'd like to close down your cameras, and then we'll have Joy, and I'll hand over to Joy now. Thanks, Joy.
Thanks, Yasmin. Welcome, everyone. So as Yasmin said, we'll be taking you through some employment law principles. So I'll go through mainly the principles and the processes that you should be expecting from your employers. And then Margaret will go through what options you have in terms of legal action that you can take. So in my agenda, there is the employment law obligations that your employers have and the processes that they should be following to go through some of the changes that you might be experiencing are happening in your workplaces. And then some issues that we've been sort of experiencing from clients or employees that we've heard, and how you should be addressing these issues. If we can move on to the next slide, please. Thank you. So in terms of employment law obligations during COVID-19, the government has made it very clear that usual employment law principles and rules still apply. What this means is that your employers should still be following proper and fair processes to go through any restructures or changes to your terms of employment. And this also means that both employers and employees have an obligation to act in good faith. What does good faith mean? I'll take you through that in the next slide. There we go. So good faith really means that you should be working together. Work together constructively and positively. Both parties should be acting openly and honestly with each other. So for example, if you have an issue, you should raise it fairly and in a timely manner. So if you have an issue with any sort of changes that your employer has proposed, for example, you should raise it straight away. Explain to them what your concerns are. Ask to sit down with them so you can have a discussion together to reach an outcome together. That's really what good faith is. It also means from the employer's perspective that they should be providing you with all the information that you need to ask these questions. So for example, if you're going through a change in the structure, if they're saying that they might be making a position redundant, or if they're going to make changes to the terms of your employment, then they should be giving you all the information possible that you will need to assess that change and assess the proposal to give your feedback. That's what good faith is. So what is a process that an employer should be following to make any changes to your terms of employment? Basically, they have an obligation, like I said, to be open and honest with you. They should be proposing the change instead of just telling you that the change is happening. They should meet with you and give you what the proposed change is. It could be change in hours, it could be change in your pay rate, Some of you may have already experienced that during the wage subsidy period. Might have been put down to 80%, for example, but that change should have been proposed in the first instance, and an explanation should have been given as to the reasons behind why that change is happening. For example, they may have said that the revenue has gone down too much. It is actually just not viable for the company to keep paying their employees at a certain rate or keep all the employees at full time. So they should explain that to you and say, and tell you what other alternatives they've looked at before making these changes, and then give you a chance to provide your feedback. That's really important. The chance to consult with you, the chance for you to sit down with them and give your thoughts on it. And only once they've had that chance are they allowed to make that proposal final. And only once you've given your consent. Changes cannot be made to your employment terms unilaterally, so they can't make the changes by themselves. They have to be in consultation with you. So once the employer has consulted with you, you can give your written consent, and then they can move on to the change. Yeah, we can move on to the next slide. So the next one really just go through a very similar process, but it's a restructure process. So restructure can mean redundancy for a role, or sort of shortening. If there's a branch, there may be some roles being made redundant and some being kept on. So some of the employees might be losing their jobs essentially. What does an employer need to do to be able to go through a restructure? First and foremost, they should be giving you a genuine business reason as to why they're going through this restructure. And a genuine business reason can be downturn in revenue again. That's probably going to be the most common one during COVID. Or it could be just we're downsizing a business because it's just not viable for us to operate at such a large scale anymore, because again, due to COVID having an impact on their revenue. So it kind of goes back to revenue in the end. What's the process that they need to follow? So like I said, it has to be a fair and proper process in that first slide when we were talking about good faith. So fair and proper process is essentially giving you all the information that you need to be able to provide your feedback, and then getting your feedback and only then finalizing a redundancy or a restructure. So it should be first meeting with the employee to present you with the proposal only. There should be no decisions made at that first meeting. The employer should clarify that, it is just a proposal at this stage. They should give you all the information. For example, if they're saying that the rationale behind the proposal is a downturn in revenue, you should be told how much of a downturn there's been, what they've done to any alternative options they've looked at in order to avoid redundancy. For example, could be they applied for wage subsidy, before they moved to redundancy, they reduced hours, they reduced pay. So that you should be made aware of those options that they've looked at already. And also any other information. For example, if they say we've lost projects, then you are entitled to ask, what projects have you lost? How much of an impact was this project going to have on your revenue? And all of that information should be provided in that first meeting when they give you the proposal. And then you should be given a chance to go away and think about the information that you've been given, seek advice on it. You should be advised that you can seek independent advice on these proposals. And once you've had a chance to do that, then there should be proposed a second meeting where you can give your feedback. So the employer should meet with you in a second meeting to obtain your feedback, where it's really your chance to speak. You explain what your thoughts are, what your questions are, and if you have come up with any alternative options. If you might have thought of any options that could avoid redundancy, and that's your chance to really present that option to your employer. And your employer has an obligation to consider that option. Keep that in mind, that even at that meeting, during the meeting, if you come up with any other options, or if you come up with any information that you need to give your feedback, you can even in the meeting itself ask them for more information and ask for the meeting to be adjourned. The process is about consulting you fairly, giving you that option to provide your feedback thoroughly. So once your employer has had that chance, then there will be normally a final meeting where they will either confirm the redundancy, and sometimes actually they may take your alternatives into consideration, and that might be what they go ahead with. So it may not be a redundancy that they're finalizing in their final meeting. Another thing to note is that redeployment options within the business. So if you're aware that your employer, even though they're going to make your position redundant, but they might have another position within the business that you can do without too much further training, then they have an obligation under the Employment Relations Act to present that redeployment option to you. And you can then accept it. It's your choice. Obviously, you can accept it or say, I'm going to just take the redundancy option, but be aware that your employer has that obligation, and you can raise that. If you're aware and hasn't been brought up to you, you can say that, are there any redeployment options? That's something that you can front foot in the meetings. So once that's happened, only then can the employer finalize the restructure or redeployment, whatever it may be, depending on what alternatives were discussed. So this is something that I think a lot of employees struggle with. They're not really aware of what process should be, their employer should be following in terms of restructures. So keep in mind that there's a step-by-step process, and it's important that employers follow that, and they need to legally. And if they don't, even if they have genuine business reasons, then you can have a claim. You can raise those concerns with your employer. And that's what good faith is, again, raising the concerns with the employer first. But if it doesn't work, then Margaret will explain what you can do, what the legal options are. I'm sorry, can we move to the next slide now? So in terms of the issues that sort of we've been seeing during COVID-19, first one has been changes to employment, terms of employment without consultation. Some of you may have experienced that, unfortunately, where the employers just told you that this is what's going to happen. But if that's happened, beware that you do have rights. You can seek advice on that. You should have been consulted before any changes were made to your terms of employment. And again, move to paying subsidy only. So the government did announce during the lockdown period that employees could be paid only the subsidy amount. And some employers just moved to that directly. But the obligation to consult with the employee was still there. So if that happened, again, beware that you had rights. You were to be consulted before these changes were made, because your pay is a term of your employment. And before any changes are made to a term of your employment, again, there should be consultation. Big one has been restructures without a proper process. And understandably, from the employer's side, companies are quite stressed too, because they've experienced quite massive downturns in their revenues. So they feel that they can justify just fast tracking through the process. But the government has made it very clear. There's been a recent case, in fact, the employment court, where the court held that even if you have a genuine business reason, you must still follow a proper, fair process. So be aware of that. A big one is employees stuck overseas, and Nicola and Deborah will touch on that one. But follow-on effect for employment for that is that employees have stopped paying some employees while they're overseas because they can't do the work. But those employees are still employees. They're still employed by the employer. So the employer has an obligation to continue paying that employee. So you have rights in that matter as well. Make sure that if that happens, you raise these concerns with your employer, ask those questions, why has this happened? And if need be, seek advice in regards to these concerns. There have also been concerns about employees being forced to take sick leave or annual leave. And again, you can't be forced to take that leave. Sick leave should only really be when you're unwell. And annual leave, you can't be forced to take annual leave. There can be an agreement to take annual leave, and there's also under the Act, the employer can direct you, but there has to be a notice period for that. There has to be a 14-day notice period, and they have to give you a direction and ask for your agreement to take that annual leave. So be aware that you can't be told that from tomorrow you'll be on 2 weeks annual leave, unless you have agreed to it. So before I pass it on to Margaret to give you sort of the legal options you have, I'll quickly touch on legal aid. So Ministry of Justice gives sort of financial help to employees or people who may not be able to afford sort of legal advice, and it's called civil legal aid. And for employment purposes, the sort of criteria to classify for legal aid is you must not be earning more than minimum wage. You cannot own a house or have any savings that I guess will be more than the minimum, or that will be higher than a certain amount. We don't really have set guidelines as to that. But obviously, if you have $1 million in savings, they're not going to give you legal aid. So be reasonable about that. And you must be a New Zealand resident. And if legal aid is granted, it's sort of given in portions. So to be able to apply for legal aid, you need to at least have applied for mediation. And Margaret is going to touch on the process that you need to follow. So if you apply for mediation, it's first of all $500 for mediation, and then the next step is normally the Employment Relations Authority if no resolution is reached. And if at the authority level, then you get $1,000, and it's a loan. It's not sort of money that is given away. So you do need to pay it back, but sort of be mindful that these options are available to you. I'll now pass it on to Margaret.
Hi everyone, and welcome. I'm going to focus on what legal action you can take to get your employment relationship back on track. The simple fact is that if you're thinking about taking legal action, that probably means that your positive attempts to reach agreement with your employer have probably failed. And when you just mention legal action, that usually makes the employer feel more negatively towards you. So legal action is more likely going to result in the employer paying you to take some money to just walk away. I understand that most people watching this webinar are employees, but we also have some, I'm going to call them workers as opposed to employees. Okay, I know that most people are employees, and I'm going to call employees workers, and we've got some employers as well. Okay, now most employment legal actions by far are personal grievances. A personal grievance is simply a claim by a worker that the employer has done something wrong during the relationship, or by dismissing the worker unfairly. So that's what a personal grievance is. It's just that claim of unfairness. So I'm going to concentrate on the personal grievance process, how much it costs, how long it might take, and what opportunities there are during the process for you to get your employment relationship back on track, if that's at all possible. So the important thing about taking a personal grievance is to get good advice early. And you want to know at the very beginning, have I got a good case? How much will it cost? What might I win? And what are my options? They're all the things that you need to know early on. And if you don't know a good advisor, then you should go on the New Zealand Law Society's website or the Community Law Centre's website. If you don't have much money, the Community Law Centre website is a good one, because they have relationships. The Community Law Centre has relationships with lots of employment lawyers who are prepared to do cases at a lower rate, and also the Community Law Centre takes on cases itself, which is good. But it's very, very important, if you want to get the relationship back on track, that you act fast before the employer forgets how valuable you are, and also because if you are going to raise a personal grievance, you must do it within 90 days of the unfairness happening. So you've got that time limit of 90 days. So if we can go to the next slide, there are 4 steps to a personal grievance, and most of what I'm going to be talking about from now on in my talk are the 4 steps of a personal grievance. So step 1 is the worker sends a letter to the employer explaining the grievance. The second step is that the worker and the employer try to negotiate a settlement by phone or by emails. The third step is mediation. And the fourth step is the Employment Relations Authority. And both parties should be trying to fix this grievance by the end of step 2. It's cheaper and it's less stressful. And 10 or 15 years ago, when I was doing this kind of work, we were always at mediation, or we were always in what was the Employment Tribunal in those days. But the national government and now the Labour government have brought in a different policy. And what that policy is that apart from legal aid being reduced to almost nothing, in the Employment Relations Authority, you can't get back really any of your legal costs. And the Employment Relations Authority has become very, very complex and expensive. So everybody these days, lawyers, employment lawyers in particular, are trying to get grievances resolved by step 2 if we can. In very few cases go to the Employment Relations Authority. Okay, so let's go to the next step, which is that first step of the personal grievance process, the worker's letter to the employer. Now you can send this letter even if you are not in New Zealand, and everyone who is subscribed to this webinar has a link to a letter template, which follows exactly what I'm describing here. You might ask a lawyer to help you with this letter. That's quite common. So the letter has to do 4 things. The first thing is the letter must describe the grievance. So, for example, you might say to the employer, I do not think a proper redundancy process was followed because you did not consult with me before you made me redundant. You must use the words personal grievance. For example, I wish to raise a personal grievance against the business. That's because you've got a 90-day time frame and you don't want the employer saying, oh, I thought that their worker was just complaining. So it is important to use the words personal grievance to make it clear that you're in that process. Step 2, the letter should describe what the worker wants the employer to do. So, for example, you might say, I would like to meet with you and discuss my employment to see if we can resolve the situation in a positive way. And if you're overseas, obviously you would say, I would like to, discuss with you on the phone or exchange emails to see if we can resolve this. Perhaps you have a suggestion that you want to put to your employer. For example, I am prepared to take unpaid leave until I can return to New Zealand. That might be a suggestion that you can make. The third thing the letter has to do is ask the employer to phone or email the worker to negotiate. So try and get that negotiation started and make your letter as inviting as possible. Even if you're really upset and angry, try and make the letter as positive as you can to generate some discussion. And lastly, the letter should ask the employer if they would agree to attend mediation if the talking and the phone calls and the emails don't fix it. So that's the letter to the employer, and lawyers do a lot of those. I've been writing a lot of those, as Joy will have been over the last 8 weeks. Okay, so let's go to the next slide, which is step 2. So that top line should read legal costs about $1,500. So that's what that top line should read. So let me talk about negotiating a settlement. When the employer receives a letter of personal grievance, they should remain calm. Responding by email is good because the employer can explain their perspective, and the employer, whether they write or whether they phone the worker, they should invite the worker to talk and discuss. It's all about that good faith obligation if the employment relationship is still going, trying to have a good conversation. If you engage a lawyer to negotiate a settlement for you, the legal costs will be about $1,500 plus gist. That will include writing to the employer, or if the lawyer is acting for the employer, responding to that personal grievance letter. It will include email and telephone negotiations. It will include preparing a record of settlement, which both parties will sign, and it will include lodging the record of settlement with the Ministry of Business, Innovation and Employment. So what might, staying on this slide, what might a record of settlement look like? If the worker is going to, if the agreement is that the worker stays with the employer, there may not be a record of settlement. It might just be a letter which says that the employee is going to return to work, and there's some payment of back pay or something like that. But if the worker is leaving the employment because the employer just can't afford to keep them on, and a payment's going to be made, what might that payment look like? I usually say, as a ballpark figure, if a worker has been dismissed and if they've got a reasonable case, in other words, the employer has made a mistake of some kind, and if the employer has the money, i.e. they're not about to wind up the company, the ballpark for an exit package is usually about 3 months net pay plus legal costs. Now, there's all sorts of variations on that, but if I'm acting for an employee, a worker, and I'm going into a mediation, and I know that my client has got a reasonably good case, that's what I'm hoping to get, that my client will come out with about 3 months pay and their legal costs paid. Now, if you can't, or your lawyers can't, reach an agreement at this happy stage of emails and phone calls, then the worker can go to the third step, which is mediation. So if we just go to the next slide. Okay, you can lodge a mediation from overseas, and you can attend a mediation by phone from overseas. That's not a problem. In fact, during COVID, all mediations were done over the phone. A mediation date is usually set down within 2 months of you applying online, but if you're still employed, you can apply for an urgent mediation, which could be granted within a week or 10 days. So if you want to keep your employment relationship on track, then it's a good idea if you can apply for a mediation while you're still employed. Try and get that urgent mediation. It's not always possible, obviously. I know I've said you should spend, a lot of your efforts on writing your letter and being constructive and all of those negotiations. That's true, because that's where you really want to resolve it. But don't spend too much time on it. If your employer is not responding promptly, or you're not getting encouraging signs from your employer that they are going to come to the party in the negotiation, move on quickly to mediation. As I say, you apply online, and it's a long process to try to apply online, but it can be done if you've got the patience. The mediation will take place at IMBY's offices throughout the country, or it might be entirely by phone, where the mediator rings up all the parties, and as I say, you could be anywhere in the world for that. If you're at the mediation rooms, the parties sit around a big table. It's not like a courtroom at all. A mediation usually lasts about 3 hours. And as I say on the slide, the mediator is not a decision maker. The mediator doesn't decide who's right or who's wrong. The mediator's only trying to help the parties reach agreement. The mediator won't tell the employer, for example, that they should pay money and how much. If agreement is reached at mediation, the mediator will prepare a record of settlement, and both parties will sign it at mediation. And as I say in the top line there, a lawyer will usually charge about $3,500 to get to the end of a mediation, and that will include the $1,500 for the unsuccessful negotiations. About 80% of personal grievances are resolved by the end of mediation. But if agreement is not reached, then the worker can lodge a case in the Employment Relations Authority. So that's my last slide. Now, the Employment Relations Authority is supposed to be a low-level and informal court, or tribunal. But over the years, it's become more and more like a high court trial. All of the parties have to prepare a written statement, all of your and a statement of problem and a statement in reply to all legal arguments. You have to have all your documents, numbered and tabulated and put in bundles. So it's quite an involved procedure. And also, when you get to it's not a hearing, it's an investigation meeting, but it's very like a hearing. There is cross-examination and all of those sorts of things. So it's very much like a district court or a high court proceeding. So that's why it's so expensive. After the hearing, the authority will make a decision, and that decision is issued in writing on the authority's website. So both parties' names are then made public. Now that's quite different to mediation, where the parties, everything is secret. The record of settlement is signed and nobody knows what was agreed or even that there is an agreement. A lawyer will usually charge about $10,000 to $20,000 just for this Employment Relations Authority hearing. And you will have already spent, either party will have already spent about $3,500 just to get through the unsuccessful mediation. And as I say, the law is that the authority will award about 4,500 plus gist costs to the winner per day of hearing, and most hearings are conducted in just one day. So you spend $23,500, let's say, and you win in the authority, but you only get $5,000 back from the losing party. So it's financially very risky for either party to go to the authority, and I think that's a deliberate policy of both first the national government and now the Labor government. And for this reason, both parties are very reluctant to go to the authority and should be very keen to settle at mediation and earlier. So there are three things that you can do, both parties can do, to try and keep the relationship on track if you have got to the stage of legal proceedings. First of all is act quickly. Secondly is be constructive. Now, Joy was talking about good faith, and that good faith is only an obligation while you're still employed. But if you've been dismissed, then still be constructive. So that's the second thing. And the third point is concentrate your efforts on writing a good letter and trying to negotiate a settlement at that point. But if that's not working and it doesn't look very positive, move on quickly to mediation, and keep in mind that 90-day limit. Thank you.
Great. Thank you so much, Joy and Margaret, for taking us through that information around employment law. What we're going to do now is we have time for a couple of questions. The audience, our attendees, have been sending through their questions. So I thought we'd pose a couple of questions to you, those, before we move on to hearing from Nicola and Deborah. So a couple of questions. People are quite interested in the subsidy as well. So Anastasia asks, during the 12-week period of subsidy, does my employer have the right to make me redundant after 9 weeks and pay the rest of the subsidy for another employee? Does someone want to cover that one at all?
To take that. So for the subsidy, it depends on when the employer applied for the subsidy. If they applied for it before 5 p.m. on the 27th of March, then they can go through the redundancy. But if it was after, then they cannot. Then they have to keep you employed for that 12-week period. Regardless, they can't use the remainder of your subsidy amount to pay for another employee. They have to reapply for that employee. They have to return your amount to MSD, or at least contact MSD and let them know that this employee's been made redundant. What do we do with the money? MSD may decide that they don't have to make another application, but the employer has an obligation to contact MSD in the first place. But yeah, around whether they can go through the redundancy or not, it depends on when the application was made.
Okay, great. Margaret, did you have anything you wanted to add to that one? Or
No,
that's all good?
And early on, we thought that they could simply just apply the money for someone else. That was the general thought, but it has been made clear that they must go back to MSD under the declaration that the employer makes if they're going to apply it to someone else.
Okay, great. And another one here, this is a more general one. Tracy asks, in terms of the issues people are experiencing with employers, do you have a view on the types of organisations, i.e. are people more at risk in smaller companies, for example? Do you have any thoughts on that?
Well, I'll take that one, Joy, perhaps. Most employers in New Zealand are small employees, so just by dint of that percentage, yes, it's mainly going to be small employees. And I act mainly for a small employee, so that's all I've seen. But we have seen big companies. We haven't seen many redundancies made, in fact, any, I don't think, in the public sector. So that's a very big organisation you're quite safe in at the moment.
Yeah, right. And maybe one last question, because I did encourage people to do a thumbs up or like questions that they wanted us to ask. So Jefferson asks, because of COVID, lots of companies would choose not to contract some employees to reduce the expense. So is there somewhere we could apply for a subsidy? And this is a question that people ask quite a bit.
Do you want to take that?
Yeah, I'm not, Margaret, you might be better to answer it because I don't quite understand. So are they asking whether the employee themselves can apply for the subsidy?
Yeah, that's what I was thinking it was asking. Yeah.
No, I think Jefferson is a contractor. Is he?
Yeah.
Yes.
If a person is a contractor, but let's say before COVID-19, you're a contractor to a company, you can apply on your own, in your own right for the wage subsidy.
Yeah. So if you're self-employed, you can apply, but if you're an employee, then you can't apply for the wage subsidy.
Okay, great. Thanks. Thank you for clarifying that. Was there anything else, Margaret, you wanted to add on to that?
No, I think if we haven't answered that, Jefferson can have another go at it and we'll try and answer it.
Great. Okay, Jefferson, get back in touch if we have kind of missed the point there, but hopefully we've answered that one for you. Okay, thank you so much, Margaret and Joy. If you just close down your mics and cameras now, because we're going to bring Nicola and Deborah on. Fantastic. Deborah, can you bring on your camera for us if you're there? Here she comes. Okay, great. Hi. Okay, so fantastic. Now we're going to move into our briefer immigration update. And for people who have joined us previously, you will know Nicola and Deborah. They joined us for our last Navigating Immigration During COVID webinar. So thanks again for being with us, and we'll just do some quick introductions to you both. So firstly, Nicola. Nicola is from Anthony Harper Law Firm, and she has over 18 years experience both in New Zealand and abroad, and she advises businesses as well as individuals. She's highly experienced in helping individuals with the immigration process, including helping resolve unusual or difficult immigration problems, which is good to know. And so also to Deborah. Deborah is a barrister and she specialises in human rights law, including refugee and immigration law. And she currently practices as a barrister at Landmark Chambers in Auckland. And Deborah is also convener of the Auckland District Law Society Refugee and Immigration Committee. And a couple of last things on Deborah. She's executive member of the Refugee Council of New Zealand and also executive member of the Human Rights Foundation. So we're really happy to have you both. Malu, if you could just bring up the slides again, and I will turn off my, here we go. I will turn off my camera and leave you guys to it. Thanks so much.
Thank you. Thanks. Hello, everyone. Shall I just start, Deborah? Yeah.
great.
So what we were hoping to do today was to sort of provide you with some practical information in terms of when you're at that negotiation or consultation stage with your employer, because as Margaret said, once you're starting to get into the legal argument, it may be a bit more difficult to come to a positive outcome. So what we wanted to do today was just to give you the information you may need to know when you're talking to your employer about your immigration status, and in particular looking after that status if you can, by way of keeping that relationship going. So if we go to the next wee slide. So the first thing that's an issue is if an employer comes to you and says, look, we need to, because of the economic situation as a result of COVID-19, our turnover is substantially reduced, therefore we need to look at reducing our wage bill, and unfortunately that means that you're in the line for that. What's really important if you're on a work visa is to be aware that you need to stay at least 30 hours of work per week. Your employer needs to understand that as well. So if your employer proposes to drop your hours below 30 per week, they're putting you in a terrible situation. You'll be in breach of your visa, but also they're encouraging you to breach your visa, which is also against the immigration laws as well. So you need to bring that to their attention. And depending on what type of work visa you're on, if you're on a work to residence visa, chances are you need to be earning at least $26.50 per hour for 40 hours a week. And if you're on a essential skills work visa, it's quite likely that your work visa will say you have to be paid at least $21.25 or $21.68 per hour. So you do need to be aware of that and point that out to your employer for the same reasons, because you're in breach of your visa, you become liable for deportation, but the employer is also breaching immigration laws if they try and continue to employ you under conditions that don't comply with your work visa. The other thing, of course, everybody's trying to do is move to another job, so there will be a lot of moving around, and if you can get another job, that's great. But you have to bear in mind that those variation of conditions, you can apply for a variation of conditions to move to another employer, but only if you're staying in the same occupation, so that same ANSCO, and also you're staying in the same location, which is normally a city, but in some cases it's a region. So do bear that in mind. For example, if you're working in Auckland, for example, and you get a job down here in sunny Christchurch, you will need to get a whole new work visa rather than just varying your work visa, if your work visa is location specific. The other thing is if you do have to apply for a new work visa, Immigration New Zealand is now very aware of the fact that the labour market has changed in New Zealand, and that there are lots of New Zealanders who are losing their jobs. And immigration law in New Zealand is very much geared towards making sure New Zealanders get the first opportunities for jobs, and migrants fill jobs which New Zealanders are unavailable or unskilled to fill. So there will be a lot more checking of visa applications in terms of making sure that there are no New Zealanders available for the job. And because of the delays at Immigration New Zealand, by the time your application is considered, it might be several weeks, and the immigration officer might be concerned that New Zealanders have become available to do the job in the meantime. So our recommendation would be for the employer to, if they can't keep the ad going, at least keep an eye on the labour market and what's happening, so they can explain why they can't find a New Zealander to do the job when your work visa comes up to be processed. So hopefully that will make sense. Did you want to add anything to that, Deborah?
No, that's very good practical advice. The whole landscape has changed, and INZ, Immigration New Zealand, is still trying to figure out exactly the approach they're going to take. They're aware of all these visas that are coming up for expiry soon. So again, it's just about being really proactive as the visa holder, and also getting your advisor to be really proactive as well. Yeah.
So for example, I'm telling most of my employers, if they can, to keep ads going, just to keep showing who's available in the market, because it is changing quite rapidly, and it could change rapidly back the other way potentially, hopefully. Okay, so if we go to the next slide. If you're lucky enough to have found a New Zealand snuggle bunny, a Kiwi, and you're living with them and you're on a work visa that's bound to a particular job, now's a really good time to apply for a work visa based on your relationship. It's not, I mean, I've been in that position myself, and it's not always something you may want to do, because you may want to stand on your own 2 feet and have a visa. But if you can, it's a good idea to get a partnership work visa, because it will allow you to go and work in any job you want to, and you can also be self-employed. So it does give you that flexibility. And also Immigration New Zealand are processing those applications very quickly right now. If your partner has if you're on the work visa and your partner's got an open work visa, you can potentially switch over if one of your jobs is more secure than the other. You may want to switch over and one becomes the main applicant and you become the partner. But bear in mind, as we were talking about before, the employer will have to advertise the position and show that there's no New Zealanders available for that role. So again, keep the advertising going whilst the process is underway. And again, this is a really good opportunity to be talking to your employer about how things are going with the company and trying to gauge what the situation is. Is there anything you want to add to that, Deborah?
I was just going to say that the priority for INZ is processing onshore applications and partnership applications. So yes, if that is an option, that's a very smart thing to go for.
Okay, so if we go to the next slide. And lots of people, last few times we've been having these webinars, have asked us about what's happening with the residence applications. And Immigration New Zealand is starting to process those again, and they've set in place some priorities. And as Deborah was saying, the priorities for people who are in New Zealand to get them sorted. And people who are earning $51 per hour, which is a very small proportion of them, that they're being given high priority. And then people with occupational registration, such as your electricians or your doctors or your lawyers and things like that. But it's really important that you're continuing to work for at least 30 hours a week, because that is something that the immigration officer is going to check when your application is finally considered. And you also got to be paid at the market rate. So again, if your employer comes to you with a consultation about reducing your remuneration, make sure that if you do agree to it, you're still at least getting paid on the market rate. And you can find that out. A good source is the New Zealand Careers website. Work to residence visa applications are also being processed again, but don't forget you've still got to meet that minimum pay level, which is, depending on when you got the visa, is either $55,000 per year or just over $79,000. And if you're reducing your hours and you're on an hourly pay rate, you may drop below that. So do think about that again when you're consulting with your employer. Anything you want to add, Deborah?
No, well, yes, just one of the themes that we've been saying throughout this is to make sure you get advice. It's really, really important. You know, I'm sure everybody on this webinar is here because they know how important your visa status is. And, you know, we can't really stress enough how important it is to go and get credible, reliable, professional advice, you know, before you make decisions such as this, because immigration is starting to wake up, it's starting to get more operational. You want to make sure that you're meeting all your conditions, and accidents can happen.
Yeah, that's absolutely right. If we carry on to the next slide. So I want to talk about staying lawful. So if you're, here we go. If you do lose your job, if a consultation happens and the end result is that you are made redundant, or for example, your hours drop below 30, or you're no longer compliant with your visa conditions, you will be liable for deportation under the Immigration Act. At the moment, Immigration New Zealand have advised us that they're not proceeding with deportations. Is that still the case, Deborah? You haven't heard anything?
That's still the
Yeah.
case.
But as Deborah said, they are starting to get operational and waking up. And if flights are available out of New Zealand, I think Immigration New Zealand will start taking action to remove people that are unable to, for various reasons, unable to pay for their own flights out. There'll be a few people like that. So the first step in that process would be receiving a deportation liability notice. And when you get that, you've got 14 days to write to Immigration New Zealand to explain why you shouldn't be deported. And then you've got a further 14 days, so 28 days from when you get the deportation liability notice, to appeal to the Immigration and Protection Tribunal if you've got humanitarian grounds why you shouldn't be removed. And it's a fairly high threshold. You're demonstrating that it would be unduly harsh or unjust for you to be removed from New Zealand, and that in all the circumstances it wouldn't be contrary to New Zealand's public interest for you to stay. So if you do have, if there's really good reasons why it would be unsafe or unjust for you to be removed from New Zealand, you do need to get advice straight away when you get that deportation liability notice, so that somebody like me or Deborah can lodge an appeal as quickly as possible. And we've got lots of time to get together documents to put before the Immigration Protection Tribunal to explain why you shouldn't be removed. Also, for example, if the situation with underemployment law, if you have raised a personal grievance and you're acting with a lawyer, or you just raised it yourself, keep all that evidence of having raised that claim. It'll be really important if you go to the Immigration Protection Tribunal, or indeed if you write to Immigration New Zealand, because they may take that into account in terms of their decision whether to remove you or not. The other thing I really wanted to let people know is that even if you're not served with a deportation liability notice, but your job ends and you don't leave New Zealand and you don't get another job, eventually when you do get another job and apply for a visa, you could have been in New Zealand for quite some time without, being there in compliance with your visa. And Immigration New Zealand in the future could say, we don't think that you're a bona fide applicant. We don't think you're somebody who's going to do what you say you're going to do, basically. And they could write letters to you and say, we don't, last time we granted you a visa, you didn't have your job, you didn't tell us that you'd lost your job, and you didn't leave the country, so we're not probably going to give you another one this time round. So I think you need to keep that in the back of your mind and keep evidence of trying to rectify your situation, find new jobs, and or leave the country, or whatever you decide to do. And actually, I would say getting advice and having evidence of having sought some legal advice would probably be quite helpful in that regard. So is there anything you wanted to add to that, Deborah?
No, thank you.
Okay. So the next slide, which is the last slide, is just about coming back to New Zealand. The reason I added this is because we're now getting to the point where Immigration New Zealand has been quite slow in processing applications. People are losing their jobs, and so a lot of people I'm hearing from are thinking about going home. And I just want to let you know that if at the moment the borders are closed indefinitely, and there are some exemptions which I'll talk about, but it is very difficult to get back into the country. So if you do go, the chances of coming back are fairly slim for quite some time, I would say. So if you're the partner of a work visa holder and you're ordinarily resident in New Zealand, then you can apply for an exemption to come back. And essential workers can apply for an exemption to come back, but that doesn't mean the same as somebody who has an essential work visa. So it's a very prolonged process if you're an essential worker to apply for an exemption. Basically, you have to write to the government, your employer has to get permission from the government department that's responsible for their industry, and then they have to have some consultation with other government departments, and once that's all through, then you apply for your permission from Immigration New Zealand to come back in. And I'm working on a few of those at the moment, and it's taking more than 3 weeks at least to get through that process. And as I said before, if you are going to go back, then make sure if you are served with a deportation liability notice, you leave before your appeal period. That 28 days is expired, because you'll be deemed to have been deported if you go after that. And if you do go back, if you stay around a long time and then go back and you apply for a visa to come back into the country again, as I said before, even once the borders are open, they might ask some questions about whether you're going to adhere to immigration rules going forward. So it really is a good idea to get some advice and sit down with a lawyer and have a proper chat about what your situation is with work, what you think is going to happen, and keep them informed, and then make a decision together, I would say, about what's the best course of action going forward for you and your family. Anything you want to add to that, Deb?
Yeah, just to pick up on that issue about if your visa runs out or you've made the decision to leave and needing to leave within that 28 days. What you can do is you can engage with the relevant immigration office directly. They're called Compliance New Zealand. So every person has a compliance officer allocated to them when they're at that point. And so my strong recommendation is get your lawyer or advisor to engage with them. But someone needs to engage with them and talk about what your travel plans are, because they can then amend your file in the system to allow you the time you might need to arrange your affairs. What Immigration New Zealand really wants is, what they say is they would rather organise a well-managed voluntary departure than an arrest and deportation. That way immigration doesn't have to pay for the flight. So, you know, they are willing to discuss these things, but again, it's really important to be proactive, and I would strongly suggest getting an advisor to get between you and compliance to discuss those matters if you're nervous to talk to them. Yeah. I had a few other things on my shopping list, Nicola. Were you? Yeah.
Go right ahead.
Yeah, so I thought it would be helpful just to update everyone here about some work that the immigration industry has been doing since our last webinar. And I think, did we have the new Immigration Act by our last webinar, Nicola?
No, I don't think we did.
Yeah.
Yeah, that was on the 15th of May, and I think the last webinar was prior to that.
Yeah, so I thought maybe an update on that. So during COVID, an immigration industry group was formed called the Immigration Steering Group, which is a very positive thing, where the two law societies and two main advisor groups joined together to be able to speak to immigration managers and the minister with one voice on behalf of migrants and concerning immigration matters. And I wanted to really just let everybody know here that this group of senior lawyers and advisors are working very hard every day on behalf of migrants in New Zealand and offshore, trying to advocate for your rights and make sure that things are done fairly, that things are explained clearly, that, you know, the processes are accessible and affordable as possible. And so we really wanted to let you all know that, because we know that sometimes people can feel very stressed and like they've been forgotten, but please know that there is a group of New Zealand professionals, you know, including people on this call here, who are working very hard to try and make sure everybody is treated fairly. Where we're at in terms of immigration, so we're at level 2 now. So level 4 and level 3 with very different conditions to level 2. And as I said, immigration is starting to really wake up now. And they are looking very seriously at what our labour market looks like and what immigration looks like in the future. And they're basically using this as an opportunity to really look again at our immigration policy. So we're not going back to how things were before COVID, and we don't know what the future is going to look like. But I think it's safe, well, as Nicola said, the policy has always been to protect New Zealand jobs, but we are saying very hard, well, we need to have that evidence base. We can't just assume that there are New Zealanders there to fill in jobs. And so that's why it's really important for employers to do that advertising, to show if they can't get someone that it's based on evidence. It's not enough just for employers to say so. So now we have 97% of immigration officers back at their desks in New Zealand, which is quite recent. Compliance New Zealand has, so that's the deportation wing, they haven't changed their approach yet, but that is just a matter of time. The Immigration Act, the new amendment, it was very positive because the industry group managed to get the politicians to agree to make sure that it put into the Act that the new superpowers given to the Minister, so the Minister of Immigration now can make decisions that affect entire classes of visa holders. Before, the Minister had special direction powers, one person at a time. Now it can be entire classes of people. And we were very concerned that that could deprive classes of visa holders from rights, but it's now in the legislation that these special powers cannot materially disadvantage any migrants. So that's a really important protection for you to be aware of. And it is an indication, I think, of good faith from Immigration New Zealand and the Minister that they're not going to use COVID to, deprive classes of migrants. So we can take some comfort in that. Although that said, everything has changed in terms of that labour market, and there's just more uncertainty. I think that's really it, isn't it, Nicola? It could all actually end up fine, but there's just chaos right now while people try and get information and data about what's happening. There is an issue about offshore migrants. I'm not sure how many are on the line here, but Immigration New Zealand is keen to know how many people keen to get back in and would be willing to pay for their quarantining. So feel free to email me with that, or email any organisation you're part of. We're very keen to hear about that. The feedback we're getting is people are willing to pay for their quarantining, but the issue is what's the cost? It will be thousands of dollars, and that's something also we're trying to work with the hotel sector to ask them how much would they charge for quarantining for 14 days. Immigration also put out every week, every Wednesday, puts out updates for all the advisors. And there are, for example, abilities to get employment visa escalations if you've got something that is urgent, but you really need an advisor to do that, or a lawyer. And we're not just saying that for marketing for us, we really want you to make sure you've got someone helping you in this process. It's a complicated process. I can tell you that after doing it for over 20 years, I still find it complicated. Because policies change, operations change, managers change. So you really need someone who knows what they're doing. And finally, we talked last time about how important it is in New Zealand, in a democracy, to speak up to your local members of parliament, to your community organisations. The ministers, the government, they are listening. They are listening to the community. And so, be brave, speak up to your community leaders to make sure the politicians they are in control of our immigration process. At the end of the day, the cabinet are in control of it. And so we're in a democracy. So if you've got issues, you make sure you speak up, please. Yeah. That's all from me.
Very good.
Thank you so much, Deborah and Nicola, for all that information, and also I think for sharing so openly with us about new developments and things that are going on behind the scenes. I think it just can make everyone feel like, okay, we're not alone. There are people there who really do want to support us and want it to be fair. So thank you so much. That's really great. What we'll do, we've got I'll ask you guys a couple of questions, and then we'll bring Joy and Marg in. So just before that, a couple of questions. So Agatha asks, hi, I want to know, if I find a job below $25, can I get an essential skill work visa approved? And also, will I be granted family status? Does that one make sense for you?
Yeah. So as long as it's over $21.68 per hour, then you can get a 3-year mid-skilled work visa, depending on the what occupation code it matches with, the occupation. And in that case, you will be able to bring your family or extend your family's visas. At the moment, you wouldn't be able to bring them in, of course, but if they're here, you'll be able to extend their visas. But you wouldn't, to get residents is $25.50 per hour, so it's a bit different.
Okay, cool. And just one more question from Viva asks, if someone in HR and applied for permanent residency, can immigration reject permanent residency application, as this job can be done by anyone by giving training?
No, because there's no labour market check involved with a skilled migrant category application. The issue is whether it's a skilled job and whether it's ongoing and sustainable. So that should be absolutely fine.
Okay, excellent. Okay, so we will bring in Marg and Joy back to us. So if they could put their cameras and mics back on, that would be excellent. And I thought what we might just share earlier, before we get into more questions, earlier we asked people joining us on the webinar a couple of questions, and I thought I'd just share those results. So we heard that 38% of people are feeling uncertain about their current situation in New Zealand. 33% are worried about losing their job, and actually 29% have already lost their job.
No, that's interesting, yes. Those figures are jumping up from 2 webinars ago, aren't they?
Mm-hmm.
Yeah, that's right. That's right. Yeah, so thank you everyone for sharing with us on that. But that, I think, gives us a really strong sense of how people are feeling and what's going on. Okay, so let's get back into some of our questions. I've got them up here. Our speakers can also see those questions. If there's anything in particular you'd like to answer, you can click on the answer live button and that will just let me know. So let's see here from some of the earlier questions. Manasa asked, can he make me redundant if I ask for work from home upon returning from maternity leave on June the 1st? What are my options here? Does Joy or Margaret want to?
The employer can make an employee redundant even if they're on maternity or parental leave. They can do that. The employer has to have 2 things that they have to prove. 1, they have to have a genuine business reason, and 2, they have to follow a fair process of consultation. So the fact that this questioner has also asked whether she can work from home, it's kind of irrelevant. The basic issue is, can she be made redundant on maternity leave? Yes, she can, if the employer has got a good, genuine business reason and has followed a fair process. Part of that fair process will be listening to this person about working from home and whether that helps the employer and therefore could save the job.
Okay, thank you. Thank you for that, Margaret. Okay, let's have a look. So there's quite a bit, because we have had a big focus on employment today, there are quite a few questions coming through. So Lena asks, if you have employed permanent position, made to work on a project and the project didn't go ahead with the effect of COVID-19 and the employer has made your position redundant, what can an employee do in that circumstance?
So did you want me to take that one, Margaret?
Yeah, that's good.
Yeah, so if they followed a proper process and there were genuine business reasons, then unfortunately there isn't much. But you'll just have to make an assessment, and this is where, you know, that comes in, where we both said, Margaret and I, that you need to seek advice early. Have a chat with someone, maybe even bring up community law and see if your employer did follow a proper process, because they may have had proper reasons in terms of the project not being operating anymore, and you were employed specifically for that project. And then they might have followed a proper process, but if they didn't, then you can raise a claim, obviously, or in the first instance, have a chat with them and see how you can resolve your concerns and your claim.
Okay.
Yes, and I've just thought of something that I had wanted to flag up before. This is just about legal aid and civil legal aid for employment. I just wanted to correct a couple of things. You can get legal aid if you are a temporary visa holder in civil matters. You can get legal aid if you have a house. But it depends on your financial picture. So the rule of thumb is a single person needs to be having an income of about 23,800 a year. If you've got a child and a spouse, it's up to 37,000 a year. And then it goes up by dependents, so depending on how many children. But even if you've got a client, say, who, or you're in a situation where you're earning 30,000 a year, you can still make an application if you can show you have a financial picture that you require it. For example, you've got a whole lot of debt, or you're, for example, funding medical care for other family members or whatever. So you can only get legal aid through a lawyer, but a lawyer should be aware that you have to look at the whole financial picture. And if in doubt, put it in. And legal aid, even if you've got a house, they can put a charge on the house. So that if you ever sell the house, you have to repay that way. Or even if you might not meet those thresholds and you're slightly over, legal aid will, for example, get you to repay $5, $10 a week. And that's another good option. So, so I think it's really important you go and explore what that is. And there's a link, I think there's a link in for some legislation, about what you can look at. So I just really encourage employment law colleagues to have a look at that.
Thank you.
To Joy, I gave Joy that information which she relied on. So
No problem. Thanks for clarifying that, Deborah.
It just goes to show that these areas are complex, and that's why it's important to just go and check things, and that's why these kinds of things are really helpful.
Yeah, no, thank you very much. That's great. Thank you. That's good information. So Paul asks here, do you need a lawyer for mediation and also for employment relations court?
Okay, well, I'll take that one perhaps, Joy. You do not need a lawyer for mediation. The mediator, if you are not represented, will look after you. If the employer is represented, the mediator will look after you even more. By looking after you, I mean they will make sure that you have your fair opportunity to talk, and they will talk to you in private quite a bit, and maybe even say to you, well, these are things that you should be telling the employer, and you will always have that backup through the whole mediation on the day. So yes, definitely you can go to mediation on your own, and many people do. Where it's difficult is at the end of the mediation when an offer has been made and you don't know whether it's a good offer or not, whether you should keep going, how much it's going to cost if you keep going. That's where it's useful to have some legal advice, but you don't need a lawyer full time for that. You can have a lawyer just on the end of the phone who will, on the day of the mediation or beforehand, say this is the kind of settlement you might accept. In relation to the Employment Relations Authority, I think it would not be a good idea to go in there unrepresented. It's a very complex process. You can get tripped up the whole time. There's telephone conferences. There's lots of legal issues often. So I think you should have some good advice there. Be represented. Okay,
great. Thank you for that. Okay, so we've got another question here. As one of the non-New Zealand resident citizens, can we get some financial supports after being redundant due to coronavirus?
New Zealand law only provides for benefits and things normally for New Zealand residents, but there is the emergency benefit that you can apply for. There's certain criteria for that, and it's very much, I believe, a case-by-case basis. So yeah, it's not Deborah's or my particular area of expertise, but we actually do have a document that gives some guidance about applying for the emergency benefits, so I can send that through to you, Yasmin.
That would be great, and we could share that in our follow-up communications with attendees. That would be really great.
And again, this is a very political issue. because under the epidemic notice, the Minister of Social Security could direct the Chief Executive of WINS to allow Social Security to be granted to people not ordinarily entitled. So what that means is for people who wouldn't normally get the benefit, they can under an epidemic if the Minister directs. And so there's work going on, very strong work, saying for people who can't leave New Zealand and don't have work, then this should be used, but Cabinet is just sitting on that decision. So this is something that really you need to get community groups talking to MPs and ministers about. And, you know, we're only a couple of months out from election. And, you know, the migrant community, you should be aware how important you are in the political calculations of political parties. You're an important vote for the, you know, those who can vote in your communities.
Yeah, absolutely. And that's actually something we shared as well after Nicola and Deborah joined us on our last immigration focused webinar. So yeah, absolutely. Very good message to raise again. And now Nellie actually had a question, quite a detailed question, but we've got time for it. And she put it in the chat box. So let me just have a look here. She says, I've been working in an essential business for 8 months through an HR company. So my employer were the HR. When the lockdown started, the company's workflow reduced drastically due to COVID and they released all temps. Then she said, the HR couldn't help me as they're not entitled to request help from the government, and neither the company as they're not my main employer. The problem is they kept me under a contract, but I never found any other temp job through the HR, and still without income since the lockdown. I couldn't request myself anything through work and income as I have a partner who's still working and his salary cut me off. How's government solution for helping people in similar situations? This is a big one. Does anyone?
Is HR all the way through that referring to the Human Resources Department of her employer or the recruitment agency or the HR agency? HR is...
As in human resources. Yes, that's my understanding, through an HR company. So her employer was the human resources. Is that right? Yeah.
And they didn't have a 30% loss of business and therefore couldn't apply for the wage subsidy. That's why?
Yes, it couldn't help me as they're not entitled yet to request the help from the government, neither the company as they're not my main employer. Yes.
So it sounds like, yeah, the HR company is it's one of those triangular relationships, isn't it? So it's a little bit hard to sort of track down who should have been applying for the subsidy. Sorry, I'm reading the question again.
Yes, yep.
So the HR company is the employer, but you were working for another company. So they were contracting you out to the other company, but then you were released as you were the temp and you were released is what my understanding is. Mm-hmm. So currently don't have an employer.
Yeah.
Which would, yeah, that's a little bit rough because obviously without the employer, you can't apply for the wage subsidy. I guess it would be just the normal benefit scheme that you would apply for, right?
Well, there's that new benefit they've announced.
Yeah.
Even if you've got a partner earning, you can get $490 per week.
Per week, yeah.
Yeah.
So that's something that might be available in this situation.
It might be also worthwhile talking to an employment lawyer because it sounds a bit odd that they were able to be released on a temping contract if they've been in that role for 8 months.
Yeah, it doesn't sound like a temp role.
No.
So would say maybe just have in detail chat about what your circumstances actually were, what the employment relationship actually was, because you may have other claims, to be honest.
Okay, so again, that's one of those complex ones where you really need some support, someone to help you guide through that. So thank you. And as we were discussing Nellie's question, actually a couple more came through the Q&A box. So let's have a look at those. Charlie asks, and this is a 3-part question. Charlie asks,
I think that Charlie one's quite complicated.
Yeah, okay. Yeah. So maybe sorry, Charlie, that one might be a little bit too much. on our webinar. But we've got another one here. A friend who is a migrant just got a new job, and because his new employer said he needs someone fast to start before a contract, and mentioned that he can easily find someone else because of lots of people looking for jobs. My friend is desperate and was told by employer he's protected somehow by 90-day trial. I've encouraged them to get a contract, but he doesn't want to lose the job. Does that legal action grievance process still apply if something goes wrong here?
Okay, so somebody, this employer has employed this guy's friend without a written employment agreement, and the employer is saying a 90-day trial applies. So the first point there is that unless you've got the 90-day trial in writing, then the 90-day trial does not apply. And for the employer to get rid of this person, they are going to have a good reason, and they're going to have to follow a fair process. It doesn't, an employer should get an employment agreement in writing, and if they don't, it will be interpreted against them. So if the employee says, I thought my terms were such and such, the authority, if you ever got that far through the process, is likely to agree with the employee, because the employer had the opportunity of writing an agreement up. So does that legal action grievance process still apply if something goes wrong here? Yes, this person is an employee, even though there's no written employment agreement.
I think this kind of case is a classic example, isn't it? Where people are scared about what to do, but clearly it's starting to go off the rails. And Marg, as you said, if they try and get it back on the rails with the employer quickly and it doesn't work, put in your personal grievance email, right? To get people to take the concern seriously.
Yeah.
Yeah.
Because although the Employment Relations Authority process is very expensive for a worker who has no money, it's also even more expensive for the employer, because they've got the burden of proving that what they did was right. So they've usually got more witnesses and evidence that they have to present. And on top of their legal costs, they've also got the risk that the judge might award a decent sum of money to the employee. So, and it's public. So next time that employer goes to immigration, or get more workers involved in their business, or it's up on the website or the internet, and they can be seen that they're not a good employer. So there's lots of reasons why an employer, it's just too risky for them to go to court. So a personal grievance is a good threat.
Yes, when I'm looking at Charlie's question.
Yes.
Yeah, it's actually a bit clearer. He's taken the subsidy in the 12 weeks when he couldn't work, and he's saying if he goes back to work and he ends up, not less than 30% to get the subsidy, does he have to pay it back? Well, the answer is yes. Yeah. Because it was there to help people who are having a shortfall. It's a good faith approach. And if you think about it logically, why would you take more money than you need? So if you've got the money you need, then you give the money back.
It's also in the declaration you make when you apply for the subsidy anyway, that you're going to return the remainder if the requirements don't apply to you anymore.
It was to protect people if they got stuck. And so if you're not stuck, then you don't need it. Yeah. That's how I think of it. Is that how you think of it, Mark and Joy?
Yeah.
Yeah.
Okay, that's really good.
A few law firms have had to pay it back. So
yes.
Yeah, so it is that good faith thinking about that. And I think that brings us to the end of our questions for now. But what I did also want to raise, and also thank Mene Stefano he's a senior advisor at Employment New Zealand. He's been on the webinar today and sharing some great information and links to Employment New Zealand information in the chat box. So that's been really helpful. And I also wanted to mention Employment New Zealand also has a free e-module, or it's a 30-minute online lesson, which makes knowing your employment rights really easy. And it's particularly been developed for vulnerable workers and migrant workers as well. And so we will share the link to that information on their website. It also involves a short quiz and a certificate, and it's available in 6 languages. So what we'll do is we'll share that information as well. Also, share any of those other links which Mena has shared today, as well as the Auckland District Law Society information guide for migrants, which we've covered a lot of that information today, but there is some really great credible information out there. So in our follow-up communications to our attendees, we'll make sure that we share those as well. So that's really good. I'll just check if when I've been chatting, we've had any more people come through, but I don't think we have. So that would bring us, finally, did our speakers have any final comments to wrap up, or we're feeling like we've covered a lot of ground? I feel like we've done pretty well, but I think it is really about, it's about getting good advice and getting that advice early and really understanding your rights. And I think some of those Employment New Zealand modules can help as well. But thank you all very much to our 4 great speakers today. I do really want to thank you, not just for your time, the time you volunteered on the webinar today, but also in the lead up to the webinar, giving, you know, helping us shape the webinar and also preparing slides and all of that. We did a test yesterday, so you have given a lot of your time, and we really do appreciate that. I hope we've been able to answer some people's questions and hopefully make them feel a bit more like they're a bit more control of their affairs at the moment. I hope it's been of benefit. But that is the end of our webinar series. So thank you everyone, and kia ora, and hope you have a great day. Thank you.
Thank you, Yasmin. Colleagues, could I just ask you to stay on the line? Megan, Joy and Nicola and Yasmin, would that be all right?
Yeah.
No problem. Thank you.
Yeah. Are we offline to the public now?
Let's just double check.